And that comes on to the second related theme, which is ownership and participation. And of course, Trinidad and Tobago as a republic, Mauritius as a republic, have decided in their own constitutions to retain the services of the Privy Council. And when I speak to people, I know there are a lot of cases from Trinidad, and Trinidad is one of the most sort of prolific appellants to the Privy Council. It gives a huge proportion of the Privy Council work comes from Trinidad, because you guys are seriously litigious, let's be honest. But when I speak to people from Trinidad about these cases to the Privy Council, they talk about it's their court. They don't talk about, oh, you know, it's the Privy Council, it's not a foreign tribunal. I don't recognise that language. When people talk about Privy Council, in large part, they're talking about their court, their country's final appeal. And that's how we think about it in Gibraltar too. And Gibraltar is obviously a British overseas territory, so these issues don't cut so deep, but it's our court. So I think there is something to be said here about ownership of the Privy Council, and whether, of course, it's right. I mean, I saw an article in the Times the other week asking whether the Privy Council is a colonial relic. And of course, in a sense, it is. Of course, it is a colonial relic, because ultimately it is a board set up to advise Her Majesty as to how she should distribute and execute justice in her dominions. Fine. But almost every institution, in the United Kingdom at least, enjoys, if you look far back enough, those anti-democratic, anti-freedom credentials. The question really is, what role does the Privy Council adopt today? And I think the relationship between Trinidad and Tobago in particular, and Mauritius also, the Privy Council, demonstrates that actually it is possible for a state to take ownership of the Privy Council and make it its own, which does bring a different. I'm not saying that answers the debate, and I'm not saying it undermines any of Dr. O'Brien's arguments, you know, on either side of the balance, but it informs the debate. Another thing that informs the debate is an assumption that the Privy Council and the CCJ each enjoy immutable, unchangeable characteristics. The Privy Council is this court in London that is manned by a bunch of, old white male British lawyers. But on the whole, of course, that's true. And on the whole, of course, it's also true at the moment the CCJ is manned by some pretty serious jurists, almost exclusively from the Caribbean region. But those are not necessarily immutable characteristics. One of the things I suggested to Sir Dennis Byron that he was not very keen on, I should say, that the CCJ could do and the Privy Council could do is to actually exchange judges. Because the Privy Council will always exist. Don't forget, there's all the British overseas territories, and there's its Scottish jurisdiction. So the Privy Council will always exist as an international common law court of high repute, always, whether the countries listed by Dr. O'Brien appeal to it or not. So it will always exist alongside the CCJ. So the only question really is whether some of those states move from the Privy Council to the CCJ. Why should the CCJ, as an international common law regional court, and the Privy Council in London as an international common law court, not engage in a process where judges sit on each other's panels? That will actually enhance the exchange of judicial knowledge, regional experiences. One of the things I regularly experience in the Privy Council, if I'm appearing on behalf of the government or on behalf of a respondent, and I want to try and get the Privy Council to dismiss the appeal, if I've got findings in my favour by the local courts, I just say, oh, don't get involved. Don't get involved. You don't understand, you know, all the local decisions are based on particular peculiarities of the cultural things that are going on in St Kitts and Nevis, and don't get involved. And it works. if you have a judicial exchange, actually, it gets behind a lot of those problems because judges start to actually understand what goes on in the Caribbean, and the Caribbean judges get to understand a little bit more about how Privy Council judges make their decisions. And, there could be a lot of the concerns referred to by Dr. O'Brien could actually be assuaged, I think, by taking that kind of more collaborative approach. It doesn't undermine the CCJ if a Privy Council judge sits on its panel any more than it undermines a Privy Council decision when judges from local jurisdictions sit on it, which they often do.